The document of title that we are going to be looking at is known as a bill of lading. And the bill of lading, again, I explain it more in the accompanying presentation. But essentially, a bill of lading is a document of title. And we call it a negotiable bill of lading because negotiation is a legal concept that says that there are certain rights that attach to a document of title. Now, a bill of lading is really doing three things. It has three roles. The first is it's a receipt from the carrier, that party that's going to carry the goods, the shipping company, the transportation company. And so when I, as a seller, leave my goods in the hands of a carrier, they're going to give me a bill of lading. And the bill of lading, first of all, is going to show it's a receipt. It's going to indicate what goods there are there and also indicate, is there any damage at the time that the goods were transferred. So first thing a bill of lading does is it's a receipt. Now, it's also a contract of carriage between the shipper and the carrier, meaning the shipper being the seller and the carrier being the transportation company. So the bill of lading will not only be a receipt of the goods, but it'll also be a contract that calls for the carrier to take the goods to the eventual buyer. And then finally, it's a document of title. The bill of lading serves as a title to the goods that are described in it. So when I talked about abstracting goods, now the important, the element that's necessary in order to transfer goods is not just simply possession, but it is the title. So what the document of title does, when a negotiable bill of lading is created, it separates ownership from possession. In the U.S., we actually have a law that governs this, a federal bill of ladings act that governs bills of lading. Just, you should know. Now, a purchaser of a document of title has certain rights. And those rights can depend on whether it's a negotiable document of title or non-negotiable. A document of title can, there's two different types of documents of title. A negotiable document of title, a bill of lading is a negotiable document of title. First of all, if it's signed, it must be signed by the party shipping the goods. The seller, the shipper, must be signed by the goods. It must include the magic phrase, to the order of a named person or assigns, or to the bearer. To the order of or to bearer. Those are magic words because if I include those words on my document of title, I am going to give to the purchaser of the title certain rights that it does not get if those words are not included. You've all seen checks, and you know that on every check that you've ever seen, whether it's your personal checks or checks from your employer, checks from your grandmother, on every check that exists, there's that phrase, pay to the order of. Well, the reason why that phrase is there is because checks are documents of title. They are negotiable. They represent money. And so when I go to the grocery store, and no one does this anymore, but once upon a time we would write out a check and we would take out a piece of paper and we would write on the check and then we would sign it and date it and then we would hand it to the cashier. And at that point, the cashier, the company taking the check, has certain rights. They can go to my bank and say, pay me for this piece of paper. And so I don't have to carry the cash in my pocket if I have this piece of paper with the magic words on it. Because now that piece of paper becomes money. When we talk about negotiation, negotiation is the transfer of a document of title by what's called endorsement and delivery. Documents of title can transfer ownership of goods because the document now reflects ownership without actual delivery, because we've separated ownership from possession. And so the important thing now is not the actual goods, but the piece of paper, the document of title. And when we transfer a document of title through negotiation, we actually give to the transferee more rights than we might otherwise have. If a party obtains a document of title through negotiation, what this does is it allows the party to take that document of title without fear of any pre-existing claims against those goods. How does that exist? Well, if I have, if I'm in the manufacturing business and I produce goods, and those goods are financed through an arrangement with my bank, and my bank takes a lien against those goods. A lien means it has certain rights in the goods. It can come take the goods if I don't pay on the loan. Well, if I transfer those goods through the use of a negotiable document of title, the party that takes those goods knows that the bank cannot come out and attach those goods. The bank can't come seize those goods because they have obtained them through the process of negotiation. Now, you have to be a good faith purchaser, meaning you must not have any knowledge of the pre-existing claim against the goods. But if you are a good faith purchaser of a document of title, you are protected. You're protected from the risk that another party may have an interest, a legal ownership interest in those goods. We call the person who receives a document of title through negotiation, we call them a holder by due negotiation, or sometimes a holder in due course. And the holder in due course who purchases a negotiable document for value and in good faith and without notice of any claims against it, in the ordinary course of business, in the ordinary course of dealing, will be protected from risk. The party who purchases the document of title for value and in good faith takes those goods without fear that another party may have a superior interest in those goods. Now, this is a big deal, because if we did not have documents of title, that means whenever you sell a good, the party taking the good is always going to have to take into account that there's another party that owns an interest in that good. And so therefore, they will have to price that into their agreement. They'll give you the value of the good, but reduced by the fact that this good may be subject to certain claims by other parties. And the same thing, if that party wanted to resell the good to someone else, we would have the same issue, that the good would have to be priced according to the idea that not only the previous owner may have given away part of the interest in those goods, but the subsequent owner may have done that. So what a transfer by negotiation does is it wipes away all previous claims against those goods. What this means, the legal effect, is the good faith purchaser takes greater rights than the transferor of the document had. Meaning, if you were aware at the time that the goods had a lien against them, but you sold them anyway, well, you didn't have a right to sell them. However, the party who takes them now can sell them without fear that the original bank can come in and grab those goods. There's actually a case about this discussed in your textbook called Banque de Depot versus Ferrolegas. And this case concerned a situation in which there were goods that were sold and a negotiable document of title was produced, and the goods were shipped, and the bank who had a lien against the goods became aware of where the goods were. And so they went and what in the law we call attach the goods, meaning they went to a court and the court said, look, those are our goods. We have a right to those. We have an interest in those. Therefore, attach those goods, sell them, and give us the money. So they found the goods, and the goods were protected by an interest, a lien of the bank. Nevertheless, what the court said is, you, bank, attached the wrong thing. You should not have attached the goods. You should have attached the document of title, because the document of title is the thing that reflects ownership in the goods. And therefore, the document of title is the important thing. The goods are relatively immaterial in terms of determining ownership. Instead, we have to find the document of title. And in this case, because the bank did not know where the document of title was, they were unable to attach it, and so the bank lost their lien in the goods. Now, the bank preserved its rights against the borrower. The transfer of the goods through negotiation doesn't free the borrower from any personal obligations, but it does free the subsequent purchaser from those obligations. If it's an order instrument, the good faith purchaser must take it by a process called endorsement. An endorsement generally is signing. When the document is signed, then it is endorsed, and therefore the good faith, that idea of endorsement, ensures that the goods are being sold without potential of claims from a subsequent party. So in conclusion, what do we learn in this lecture? Transaction risks can be thought of as delivery risks and payment risks. The documentary sale is a transaction, a legal framework to allow parties to conduct business at great distance. And we also know the CISG contains provisions regarding allocation of loss. When you look at delivery risk and payment risk, once again, the most important way to control those is through the use of Incoterms, those trade terms that we discussed in our formation lecture. And that's it. Thank you very much. Be sure and let me know if you have any questions.